Have you seen this? If you haven't seen this, you need to see this. Let's listen to how the acting public protector answered this fundamental question of law.
What is the lodestar, the guiding principle now thrashed out by our courts of the method that is to be used for a proper interpretation of any statute or law?
The proper interpretation of any statute of the law, firstly, the supreme law of the country is the Constitution. So in interpreting that law, you need to look at what were the objects of the Constitution, what is the principle and the values and the spirit of the Constitution in line with that particular law.
Maybe we're missing one another. There is a court case of the Supreme Court of Appeal which is now settled in the constitutional era. What is the approach anyone who interprets a law must take? What is that case?
Recently, there is the case of the SARS, which the court took in interpretation of the Tax Administration Act.
Are you aware of Natal Joint Municipal Pension Fund versus Endumeni?
No, I'm not aware of that case.
So that's actually the case, and the case says that context, you refer to context, must be given by the apparent purpose of a provision. Now, what's the purpose behind the provision in Section 196, which says the President and members of the Executive cannot have other paid work?
The purpose for that is to ensure that the duties that the executive undertake become the primary duty, and that it is not overweighted by the secondary duty, which is the private interest, and further that there is no risk of a conflict between the primary duty and the personal interest.
Yeah, well, that the member of the executive do not expose themselves to the potential of a risk.
Indeed.
Of conflict of interest.
Indeed.
So, in your Pala report, though, that second leg is nowhere to be found. Would you agree? You only say that ultimately the financial interests did not distract the President unduly from his primary responsibilities.
Not at all, Honourable Member. We discussed the issue of the conflict of interest in the Pala report. Now, primarily what we need to look at, which we actually have interacted with, which has also been confirmed by the Constitutional Court in the recent case of the suspended public protector, whether there is a real risk. Now, there mustn't just be a suspicion or a far-fetched risk or any other potential which is not related on whether there is a real risk of a conflict of interest in the particular matter. And that we have interacted with in our report.
Yeah, no, it's bad. It's bad. The failure to identify the relevant case law is something that is quite significant when someone is a legal practitioner who's working in that legal space on a regular basis, and also someone who has the responsibility of investigating violations of critical statutes such as Section 96 of the Constitution, the Executive Members Ethics Act, and making determinations upon that. The fact that she didn't know the answer to that question is quite grave. It's quite grave. This is fundamental stuff. It's first year and second year stuff. And as he said, there are two answers she could have given that would have been at least face saving and showed that she really has recently looked at this. Remember, they've just spent a year doing the Pala investigation. So the fact that she didn't know is worrying. So the Endumeni case is the first one, Endumeni case. And the second one is the Cool Ideas versus Harvard. If she had said any of those two, she would have been fine. You know, for the purposes of just like showing that she has an understanding of the interpretation of statutes at the very core level. But she didn't know. You know, there are certain cases that you do need to know in legal practice. There's certain cases that every law student is expected to know. And the fact that she didn't know this, one of the famous cases is Bear. If you don't know Bear, or you don't know the Prince case, or you don't know the Pillay case, people are going to ask you serious questions about your legal acumen and your mastery of the fundamentals of legal theory. They're going to ask you serious questions, and those questions will be fair. I think this guy from the Democratic Alliance already had a suspicion that she was not familiar with the Mdumeni case. I think he already kind of was leaning that direction. So this question was a setup, but it was a fair question, because proficiency in your field is important if you're applying for a position such as the public protector one.